Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. Ever Googled your name and gotten a result that made your stomach drop? That name search shock is exactly why a 2014 court case in Europe changed the internet. A Spanish man, Mario Costeja Gonzalez, Googled his name and found links to a 1998 newspaper notice about a debt-related property auction. It was old, it was resolved, and it was the top result people saw about him. He asked the newspaper to remove it. They said no, it was lawful and historical. Then he asked Google to delist the link from searches of his name. Google said also no. So he went to Spain's Data Protection Authority, AEPD. They told Google to remove the links, but not the newspaper article itself. This escalated all the way to Europe's highest court, the Court of Justice of the European Union. Case name: Google Spain versus AEPD and Mario Costeja Gonzalez. Here's the ruling in plain English. 1. Search engines aren't just neutral indexes, they're data controllers. That means when they organize and serve up info about you, they're processing personal data. 2. EU data rules apply to a search engine if it has operations tied to the EU, like ads sold in Spain, so it can't duck responsibility by saying the servers are somewhere else. 3. People can ask search engines to remove links that show up when you search their name if those links are inadequate, irrelevant, no longer relevant, or excessive. 4. It's not automatic. You balance privacy against the public's right to know. Public figures, recent, newsy info, that usually stays. Notice what this is not. It's not deleting the original page. The newspaper article didn't vanish. It's about delisting, removing the link from name-based searches. The content can still exist and be found in other ways. This became known as the right to be forgotten, later baked into the EU's GDPR as the right to erasure. Since 2014, millions of URLs have been requested for delisting, and a significant chunk have been removed after review. Is it about a private person? How old is the info? Is it accurate? Is it about crime? Public roles? Professional misconduct? Does the public interest outweigh the harm? There were follow-ups. Another case said delisting doesn't have to be global. EU countries, yes, but not necessarily the whole world. And courts kept refining the balance between privacy and free expression. Why should you care? Because your past shouldn't automatically be your headline forever. But also, the public needs access to information for accountability. This ruling forces platforms to navigate that tension, case by case. If you've got a result that's outdated or unfair, you can submit a delisting request to search engines in the EU. They'll review it against those criteria. Not a magic eraser, but sometimes it's the reset your name deserves. So yeah, name search shock is real. But thanks to a guy in Spain and a landmark 2014 decision, there's now a pathway to context, fairness, and a little mercy from the algorithm. Thanks for watching. If this helped, drop a like and subscribe, and maybe Google your name with a little less fear today.